Hey, how you doing? This is Adam Post, publisher of more than 1,000 comic books and marketing expert covering Judge Block's illegal Title IX rules turning biological sex into gender. Let's get into the story. Before we do, please be sure you are subscribed to the channel. Click the bell for notifications. Give me a thumbs up. I really appreciate you guys. Well, you can always count on Texas to be aggressive and stand up for people's rights. The Biden administration has made changes to Title IX, trying to push rules to promote their political agenda. But it almost feels like a religious agenda. I can't even imagine that this conversation we're having about this is about a political belief. This is an ideological, religious type belief. It's something you're supposed to take on faith. There was no scientific breakthrough proving all of this progressive ideology. That now, because look, it's obviously scientifically correct, we need to accept this and push this through all of our society, all of our schools. There was no such breakthrough, so none of this makes sense. So when the federal government gets sued over these unconstitutional rules, of course they're going to get stopped in some places. From the Daily Wire, Biden's Title IX transgender guidelines for public schools blocked by Texas judge. And in a separate lawsuit, this was from April, Republican-led states sue to block Biden protections for transgender students. And of course, it's not just protections. It's really pushing this into society to completely change the identity of what it means to be a human being. That's coming from the federal government. It's not even coming through legislation. But even through legislation, it wouldn't be appropriate. They would lose this on legislation too. It's too aggressive. There is no social agreement on these new definitions of gender and humanity. To think that the federal government is trying to just push this out without the acceptance of at least the great majority of Americans is unbelievable. From the Daily Wire, Biden's Title IX transgender guidelines for public schools blocked by Texas judge. A federal judge ruled on Tuesday that Texas did not have to follow guidance from the Biden administration, which interpreted prohibitions against sex discrimination to include gender identity and sexual orientation. The judge ruled that Biden's education department had unlawfully exceeded its authority when it issued guidance in 2021 that opened up the door for schools to be liable for discrimination if they adopted policies like limiting bathroom access on the basis of sex. Texas Attorney General Ken Paxton sued the Biden administration in June 2023 to shield Texas from enforcement of the policy. Quote, nothing in the statute expressly prohibits discrimination based on gender identity or other expressed grounds, according to the U.S. District Judge for the North District of Texas, Reed O'Connor wrote in a 112-page ruling. We do have the whole ruling. We'll look at a little bit of the ruling, but it is 112 pages. And where Title IX allows for differentiation based on sex due to biological differences, such as intimate facilities and athletic teams, recipients may treat persons in accordance with their biological sex without regard to subjective gender identity. Paxton's lawsuit came after the Education Department released a memo on June 22, 2021, saying that it interprets Title IX's prohibition on discrimination on the basis of sex to encompass discrimination on the basis of sexual orientation and gender identity. And the way I see it, it's as if they're trying to incorporate biological sex under gender identity. And of course, if you listen to what some of the progressive people say about this, the people pushing the gender identity agenda, they've decided that gender identity exists and biological sex does not exist. A little bit hard to follow, but obviously there's some disagreement there. The department also said that it would fully enforce Title IX to prohibit discrimination based on sexual orientation and gender identity in educational programs for schools that receive federal funding. This means schools could face legal challenges if they had policies in place that said transgender identifying students would have to use the bathroom facility or play on a sports team based on sex. Judge O'Connor disagreed with the Education Department, saying that it was not logical to include gender identity under sex. Quote, Title IX explicitly appreciates the innate biological variation between men and women that occasionally warrants differentiation and even separation to preserve educational opportunities and to promote respect for both sexes, the George Bush appointee said. The guidance is different from the widely challenged Title IX rules unveiled in April that officially add gender identity and sexual orientation into federal education discrimination law, which you would say, okay, if you're going to add these brand new concepts like gender identity and sexual orientation that are not part of law, There just exists as what you're trying to do with regulation, and then you want to incorporate that into federal education discrimination law. That's a little bit too much of a leap. Ken Paxton celebrated the judge's decision, saying Biden's guidance was dangerous. Quote, Joe Biden's unlawful effort to weaponize Title IX for his extremist agenda has been stopped in its tracks, Paxton said in a statement on Tuesday. Quote, threatening to withhold education funding by forcing states to accept transgender policies that put women in danger was plainly illegal. Texas has prevailed on behalf of the entire nation. And the result of this lawsuit was Texas winning in a summary judgment. That means there isn't going to be a trial. The judge has decided, yeah, this doesn't work. This isn't legal. It doesn't mean that the government can't appeal. They certainly can appeal to Texas's appeals courts. And then beyond that, wind up in the Supreme Court, which it looks like this is going to wind up. The guidance had been previously blocked from being enforced in 20 other states where a coalition of Republican attorneys general had challenged the policy. Separate from this other lawsuit. From Reuters, Republican-led states sue to block Biden protections for transgender students. 9 Republican-led states and several conservative groups filed lawsuits challenging new Biden administration regulations that bar schools and colleges that receive federal funding from discriminating against students based on their gender identity. The states and advocacy groups filed the lawsuits in federal courts in Alabama, Louisiana, and Texas, challenging new U.S. Department of Education regulations that extend sex discrimination protections in federal civil rights law to LGBTQ students. And they can add letters to that LGBTQ word anytime they want to. That acronym could be as many letters as they want to. And they can say, listen, we just added a new letter. This is what this letter means. You need to do what we tell you to do under sex discrimination law, or else you've broken the law. Of course, that has to be adjudicated. It can't just come down from the federal government. There's no agreement in society on any of these changes. The department said the regulations issued on April 19th clarified that the prohibition against sex-based discrimination in schools and colleges that receive federal funding contained in Title IX of the Education Amendments of 1972 also includes discrimination based on sexual orientation and gender identity. So they just announced that on April 19th. So accept it. And if you don't accept it, too bad. We're taking your funding away. That's not like it belongs to the federal government. The federal government is just handling and distributing the money on behalf of the citizens of the country. It's not like the federal government has its own money. It just has access and control of the people's money. The department cited a 2020 U.S. Supreme Court decision holding that a ban against sex discrimination in the workplace contained in a different law, Title VII, covered gay and transgender workers. Courts often rely on interpretations of Title VII when analyzing Title IX, as both laws bar discrimination on the basis of sex. The regulations also change how schools subject to Title IX respond to reports of sex-based discrimination and harassment. In a lawsuit, Republican Texas Attorney General Ken Paxton said the Supreme Court's decision on Bostock v. Clayton County did not extend beyond Title VII to other federal laws prohibiting sex discrimination. That lawsuit, along with a separate one filed by Republican states attorneys general in Louisiana, Mississippi, Montana, and Idaho, argued that regulations unlawfully interpret Title IX in a way that conflicts with the statute's text, which they said defines sex as a person's biological sex. A third lawsuit by Alabama, Florida, Georgia, South Carolina, and 3 advocacy groups challenged that provision as well, as parts of the regulations, they said, broadens the definition of sex-based harassment and required schools to overhaul how they addressed complaints. Now, from the judge's 112-page order, here's his basic finding. Having considered the briefing and applicable law, the court concludes that defendants, that is, the federal government, cannot regulate state educational institutions in this way without violating federal law. Accordingly, the court holds that defendants engaged in unlawful agency action taken in excess of their authority, all while failing to adhere to the appropriate notice and comments requirements when doing so. Therefore, the court grants plaintiffs' motion for summary judgment and denies defendants' cross-motion to dismiss. They were trying to dismiss the state's lawsuit, and that didn't work. Background: on June 14, 2023, the state of Texas filed this lawsuit against the United States Department of Education, Miguel Cardona in his official capacity as Secretary of Education, the Department of Justice, and Merrick Garland in his official capacity as Attorney General of the United States. The department is the federal executive agency responsible for administering and enforcing federal education assistance, including Title IX. The other federal executive agency in this lawsuit, the DOJ, is also empowered to enforce Title IX. In response to agency action taken by defendants, plaintiff asked the court to 1. Vacate and set aside the June 22, 2021 Notice of Interpretation, the June 23, 2021 Dear Educator Letter, and the June 23, 2021 Fact Sheet. 2. Declare the guidance documents unlawful, along with the underlying Title IX interpretation, and 3. Enjoin enforcement or implementation of the guidance documents and the underlying interpretation. In support of this request, plaintiff brings 2 claims. 1. That the guidance documents are not in accordance with law and are in excess of statutory authority because they rely upon the interpretation of Title VII described in Bostock and apply it to Title IX. And 2. That there are substantive or legislative rules that require notice and comment rulemaking. The parties separately move for summary judgments on these claims. Additionally, defendants assert 5 jurisdictional challenges, arguing that any one of various jurisdictional arguments warrants dismissal prior to the court's consideration of the merits of the plaintiff's claims. Another key point, the guidance documents that were issued by the government build on previously enjoined guidance issued under President Obama. On June 22, 2021, the department published a Notice of Interpretation in the Federal Register to clarify its enforcement authority over discrimination based on sexual orientation and discrimination based on gender identity under Title IX in light of Bostock. But Bostock only relates to Title VII. In the notice, the department explains that consistent with the Supreme Court's ruling and analysis in Bostock, it interprets Title IX's prohibition on discrimination on the basis of sex to encompass discrimination on the basis of sexual orientation and gender identity. The department asserts that this interpretation flows from Title IX's plain terms, which are similar to those of Title VII, as well as case law recognizing that Bostock's reasoning applies to Title IX. However, the notice also conveys that this new interpretation will guide the processing of complaints and conducting of investigations. The notice states that it does not itself determine the outcome in any particular set of facts. Likewise, the notice explains, similar to the Supreme Court's interpretation of Title VII, the department's interpretation of the scope of discrimination on the basis of sex under Title IX does not require the department to take a position on the definition of sex, nor do we so here. The department also issued a Dear Educator Letter, as well as a fact sheet talking about violations based on their new set of rules. As they say here, consider one example the fact sheet condemns as violative of Title IX. On her way to the girls' restroom, a transgender high school girl is stopped by the principal, who bars her entry. The principal tells the student to use the boys' restroom or nurse's office because her school records identify her as male. Take another example. A transgender high school girl student joins her friends to try out for the girls' cheerleading team, and the coach turns her away from tryouts solely because she is transgender. When the student complains, the principal tells her those are the district's policies. Finally, as a third example, the fact sheet explains that referring to a transgender student by a name or pronouns other than the ones that the student prefers would be discrimination under Title IX. However, that's not how they do Title IX in Texas. In Texas, state officials administer numerous educational programs across thousands of institutions at the state level through constituent agencies and political subdivisions. Local school districts and charter schools, quote, have the primary responsibility for implementing the state's system of public education. However, the Texas Education Agency administers all federal and state funding, which includes distributing those funds to local school districts. The guidance documents impact all Texas educational entities that accept federal dollars, including Texas schools that receive substantial funding. In fiscal year 2022, Texas distributed approximately $9.29 billion in federal funds to Texas public schools. In the same fiscal year, Texas public school districts received approximately $5.47 billion in additional federal funding. So Texas is handling billions of dollars with thousands of agencies, coordinating services. They're not in a position to go and even try to micromanage this, even if they wanted to. Clearly, Texas doesn't want to because they consider this a violation of parental rights and also a violation of students' rights. They won this in a summary judgment. The government will appeal. Eventually, it will get to the Supreme Court. In the meantime, changes won't be made because they lost the lawsuit. Let me know what you think of all this in the comments below. Always love to see your ideas. Please be sure you are subscribed to the channel. Click the bell for notifications, give me a thumbs up, and I'll see you again soon with another story. And if I don't see you, I will miss you.